Welcome to Chatting GPT, the podcast where I get to speak to interesting humans who are implementing AI. I'm Maryrose Lyons, the founder of the AI Institute, and today I have the great pleasure of speaking with Jo Joyce. Jo is a partner at law firm Taylor Wessing. She's based in Dublin and where she leads the technology, IP and information team for Ireland. And there she focuses on data protection, AI regulation and cybersecurity. Jo, you are very welcome to the show.
Thank you so much for having me.
I am so looking forward to speaking to you. Now, I should actually mention as well, congratulations. She was promoted to partner in 2025, and she's the co-lead of the cybersecurity practice and advises clients in like tech, communications, e-commerce. So if we want to actually find out what's really happening with the EU AI Act and data security, Joe's the person who's going to shine a light. What is keeping you curious and excited in the work that you do right now?
But I think the thing that keeps me curious is just the possibility. I think when you and I were last talking, Maryrose, I was giving an example to a group of people about when I was a trainee solicitor, what feels like 500 years ago, but it was about 16 years ago. When I was I had a lovely partner I was working with who was absolutely terrified of doing things by email or electronic bundle filing or anything like that. He was very concerned that we were all going to lose our jobs because everything was going to become so efficient and there'd be no work for anyone to do. And little did he know that from the day that I was handed my first work phone 15 years ago to this day, I don't think there's been a single 24-hour period when I haven't looked at my emails. And I'm thinking that this might finally be the industrial revolution that actually reduces the workload rather than increases it. There is just simply no end to the amount of streamlining and possibility out there. And there is also a generational shift and a pushback in terms of the way people work as well. This is also the first sort of industrial revolution that's really impacted the middle classes as well, and people who have a strong voice and can really argue for themselves. So I think we might actually finally be seeing technology that makes our lives genuinely easier and gives us less, not more work. So that's what the hope I'm clinging to right now as I look at the vast piles of legislation growing on my desk.
That is the dream. I don't know. I've been kind of like operating in the short term and the medium term. Like I see it as that. I'm investigating and thinking a little bit about the longer term. And I think there's a few different futures that can happen, but we're not here to talk about that today. Today, we're going to talk about more exciting things. We're going to talk about, can I go straight into the EU AI Act? Because it
You
is one of my
absolutely
favorites.
can.
And I'm actually
Yeah.
on the record as saying never before has an act been so sexy and exciting to people who are non-lawyers.
That says to me you haven't read the GDPR, but go on. I'm all ears.
No, I live GDPR, but I just haven't gotten around to reading the whole thing yet. But I suppose really with the EU AI Act, I suppose there's a lot of things we could go. The first thing I want to go into is there's this anxiety or this message that the EU AI Act or the AI Act is going to crush innovation, that it's holding Europe back. It's going to really hold back smaller players. What's your view on that fear? Is it overblown or are there genuine hurdles that the Act is putting in front of business owners who want to innovate?
I mean, both, in all honesty. It is a bit overblown, as with kind of every big legislative change, particularly where it has a universal impact and it's not just targeting particular sectors or very large businesses. That does lead to alarm. I think it's also fair enough because it comes at a time of sort of legislative fatigue as well. There's been so much digital regulation. So if you are in any kind of interesting startup or scale up in the digital world, which is most of them these days, you have already had a lot to contend with in terms of change. Some of it sector focused, some of it more general. So it is perfectly reasonable for people to feel a little bit exhausted at the prospect of yet more regulation, particularly when actually, if you're operating a kind of an AI driven business or you're looking to do interesting things with AI in any business, the likelihood of you being just in Ireland, say just in the EU or even just in Europe is actually smaller. So you've also got lots of other regulation to think about. We think about China as being a sort of a very different place, but there's really intensive AI regulation in China that's in place and is working there. So it's absolutely reasonable enough, I think, for people to look at the legislative horizon and feel a little bit exhausted and fearful. But businesses very resilient. European businesses definitely do struggle with the sheer volume of additional obligations they have, but they also have a stronger basis, stronger guardrails, more user and consumer trust because there is these legislative regimes. This follows to some degree the model of the GDPR, which we were talking about earlier, and creating universal obligations and being very kind of user and consumer focused. And I think that gives advantages as well as challenges.
Absolutely. I think when I met you first and we were speaking at the same event, like I was very much speaking about Ireland's position in the world. And like we're in such a strong position, given that we are
Yeah,
English speaking, we're on the edge of Europe, but that we are operating in a compliance strong state or region.
yeah.
But yeah, talk to me about the Chinese regulation because you never really hear much about that. You hear about how China's such a brilliant player. Like, what's their regulatory system like?
It's definitely less time consuming in terms of the legislative process. These things are more largely determined by committee than they are by the many years of debate that goes on in the European Parliament and many versions of law that the European Commission produces for review and rejection and more review. So it has been quite a sort of a top-down diktat. But my understanding, and I will say I am not an expert in the law of the People's Republic of China, is that it has been quite user focused, quite focused on trust and transparency. So there are absolute kind of synergies with what the European model is trying to do there. I think that there is definitely a difference in enforcement depending on what type of organisation you are and whether you are of interest or value to the Chinese state.
Yeah.
But it's quite a good example of early adoption of regulation that has been done largely as a matter of kind of instilling public confidence. China wants its entire industry, all industries, all sectors to be embracing AI and is prepared to do what's necessary to both economically force that, but also to give people some degree of confidence in it. So it's quite an interesting example, I think, of regulation that is partly designed to boost innovation. And I think in reality will probably be a little more successful in that than the EU model, at least initially.
Yeah.
Yes, but obviously, I say obviously, maybe it's not obvious, but I wouldn't exchange a robust debate in a democratic system for a
Yeah.
different model. That wouldn't be my preference. But there is no denying that in some respects, for some organisations, it has its advantages if you can be effectively first to market with regulation. I think if the EU could be faster, and of course it outstrip the US. Various political challenges there mean that federal AI governance is, except in small pockets of particular areas, is not likely anytime soon. The fact that China hasn't done something that massively diverges from the EU is probably quite helpful, because if we want those values around transparency and accountability and focusing on high risks and managing on a sort of proportional basis to be adopted, the fact that they're not a million miles apart will probably make it easier to get some more kind of consistent rules in place.
And can I ask you this, Joe? Like the Chinese have their regulation before the EU AI Act, or did theirs come out after? Sorry for being so ignorant. I should know.
No, before, yeah,
Okay.
and
Okay.
gathering relatively little attention. I was speaking about this at
Yeah.
a conference, and someone was saying the Chinese will just be doing whatever they want, and I was like, I beg your pardon, they won't. They've regulated in a relatively strict way and are
Mm.
enforcing. So
Yeah.
yeah, no, they were ahead of the game in that respect.
They're ahead of the game in a lot of respects. But come here,
True.
going back to the UAI Act. Okay, so as we know, for anyone listening, okay, you've got four categories of risk. Okay. The one category that, okay, so you've got four categories of risk. You can talk through them now, Joe, rather than me. But will you speak to the high risk one? Because that's the one that
Yeah.
I find there's more ambiguity about how to stay on the right side of that.
Yeah, and we have some prohibited systems. So there are some things that the European community has collectively said, no, we don't want these being done with AI, and that will likely remain the case.
I like that.
All
You
sorts
know, your
of,
government can spy on you.
yeah. There are certain things that we're just going to say, just no. You
Yeah,
shouldn't be doing these anyway. You definitely
yeah,
shouldn't do them with AI.
yeah.
But I think the most interesting is, as you say, the high risk systems. And there are some systems that are inherently high risk because they are fulfilling a safety function. So it's effectively a safety component, or it's a product in of itself. It's a system and it's an automated vehicle, say. And so that's just inherently high risk. We can't have automated cars going off the roads. But then we have this whole other range, this list of, I think, 8 contexts in which if you're using AI in that situation, it will be deemed a high-risk system. So we've got biometrics, if we are using biometrics for security or identification, other means. inherently high risk. So there goes all that facial recognition, CCTV, any kind of critical infrastructure, education, employment, essential access to essential services, so public sector services in particular, law enforcement, immigration, and then justice and democratic processes as well. And I
Recruitment.
think if you, and sorry, I was including that in employment, but yes,
Oh,
yeah,
right,
employment
right, yeah.
recruitment.
Yeah.
And some of those are very obvious. You think, yes, I think biometric, I think law enforcement, I think, yeah, these things should be. Sometimes there will be systems, though, that are designed for one use and people start to use them in another way, or they adapt them. You cease to be a producer, you cease to be a deployer, you become a producer because you are starting to use a system that wasn't necessarily designed for recruitment processes to sift CVs or to make decisions based on interview technique and things like that, that then they shift into being high risk. So it's quite important that people are thinking not just what is this designed for, but what is this going to grow into?
I think though the thing is like people are aware of when something moves into high risk, but I don't think they're as clear as to what they should be doing.
I think that's absolutely fair. And that's because there has been something of a lack of clarity. One of the challenges, although we think of EU law as turning up and everything is super clear and we know what to do, we also have 27 member states that all actually have to work out how does this work in our context. In Ireland, we have adopted this sort of distributed model of regulation where we're going to have a number of organisations that are designed to safeguard people's rights, but also a lot of other organisations, 15 of them, that are going to be picking up the requirements to actually monitor what's going on in the sector. And some of those will be as expected, our Media Commission, Commissioner Mann, the Data Protection Commission, of course, but also the organisation that's in charge of marine and maritime mapping. I'm so excited to see what those lads get up to. But because they've got this sort of disparate approach for us in terms of who's going to be governing what, how's it going to be managed, we're still waiting for a lot of guidance that, there has been some from the European Commission, but I think a lot of those regulators and bodies will be producing their own guidelines. I think working out what do I do, and certainly what do I do if I don't want to pay a team of lawyers a lot of money. I'm obviously all for people doing that, but of course. But actually, I think there is a challenge of people working out, A, am I falling into one of these categories, and B, what do I do about it? There is a lot of uncertainty there.
What worries me is the bit there where you said about each of these bodies is going to come up with their own set of regulation. Are we going to have a system where
Well,
we're going to have
guidelines certainly.
like the Leos,
Yeah.
where they all have their own ways of doing things?
Yeah.
But I suppose a thing I'd actually love to get an update from you on is in June we had Caro Robson on the podcast, and she was speaking a lot around. She's talking about geopolitics, China, America, and so on. She was speaking about the
Yeah.
EU AI Act, and she was saying that of all of those bodies, there was a certain requirement that by June they had to every country in the EU had to have set up the bodies. And I was like, excellent, Ireland's really behind this. And she said the only country that has set up all the bodies at this point, that was June, was Malta.
Yeah.
Have we moved on? Has Ireland set up the
We
bodies?
we have moved on. We have moved on.
Right.
In September, there was a ministerial announcement, very exciting, to tell us that, there was going to be a new central kind of AI body that would be governing, so a national AI office that would be coordinating the activities of all of the other regulators and market surveillance authorities, as we call them in the EU, that will be governing this process. So that will be in place by, I think the aim is August of 2026. So that's still being set up. But all of those entities that are responsible for regulation and for effectively
They'll feed into that.
looking at their existing sectors and rules and duties will feed into that. And they were designated. And whilst we weren't first out of the gate like Malta, I think Ireland was the 6th member state to designate all of its bodies. It's quite interesting, things like the AI Act, the Digital Services Act, we're right up there where there's a sort of a big tech motivation. There are some other areas of law where we're a little bit behind.
Yeah, no, we're very good at following the rules like that. Oh, it's the forum with the big text.
Absolutely, absolutely. Yeah, we want to keep those delicious tax euros. We're pretty good at that and getting that set up already. So there's definite progress going on there, and there is a reasonable amount of, I think, support and guidance turning up. I think the other thing everyone has to bear in mind is to not panic just yet. Whilst we do have aspects of the AI Act in force, other things are going to be a matter of progress, and there may be some gentle shifting and changing as well, because the EU is looking at relaxing some of those rules.
That's what I was going to ask you about, the gentle shifting and changing. There's a little bit of a sign of softening on the act. Obviously, pressure from the US. So what do you do to prepare for this?
as part of its sort of big omnibus package of trying to
You were
reduce some
very
of the
excited
regulatory
about that when we
burden.
met.
I
The
was,
omnibus.
yeah, when we met, we'd had a leaked copy, I think, at that point. It's amazing to me how
Exciting.
many people are prepared to leak draft EU regulations and
I
how
think you
many
were
of us
on
are
your
excited
holidays,
by
weren't you?
them.
And you were reading it all and
I was like seeking hotel Wi-Fi to scroll through it on my phone, and I think it's one of those things that there was a reasonable degree of fanfare. A few of the kind of sexier proposals have not made it into the draft that's been published, but there will be some relief in terms of deadlines and in terms of the sort of overall amount of sort of compliance paperwork and external reviews and required for some high-risk systems that are being produced by smaller medium-sized organisations. So there is
Joe,
going to be a
so
little
when are they
bit
going
of
to sort
relief
this
there.
out? Sorry to interrupt you. When are they going to sort this out?
Yeah.
If I'm a company and I'm sitting there going, I want to comply, I want to comply. Oh, they're going to soften
Mm,
it. I might just. It's a little bit like the TV license in Ireland at the moment.
very much.
Are they going
Yeah.
to change it up? Will I wait?
Honestly, that is a real concern and something that I and lots of other people have been talking about, because the particular legislative process, this omnibus process that the EU Commission is looking to use to make these sort of changes to a whole range of bits of digital law, not just the AI Act, is not necessarily a uncontroversial approach. It will reduce the amount of debate. It is designed for kind of more administrative changes and technical changes than
Mm.
things that significantly impact legislation. There will be changes to the GDPR, for example, brought in at the same time if it's successful, which there is a suggestion that there should be more debate around those. So there is still a possibility that process will be legally challenged and that there will be other changes. So my advice to organisations that I'm speaking to about this is that don't place too much weight on the possibility of relaxation. If you've got to the stage where you're already doing some of the kind of the technical reporting work that might be eased up or might not be by this legislative change, then you're well ahead of the game anyway, frankly. So I would keep on the path that you've stuck to. You may later be able to relax things, and that's all to the good. But I think there is no great benefit to pausing on work now. Particularly, one of the things that was flagged to me recently was, oh, this is great because this moves the obligations around literacy and making sure
Training.
that the workforce and training understands what's
Mm.
going on from organisations onto member states and the EU Commission. So wasn't this great? I was thinking, not really, because actually the one great thing about the GDPR was the requirement. I think there are a number of great things, but what thing that universally I think has been helpful is the expectation that no, really everyone has to understand what's going on here. Everyone has to have a slice of this, a tiny bit of obligation. You might not be the person that's in charge of AI for your organisation, but if you're using it, you not only do you have a right to know and understand what's going on, but also it is an expectation on all of us to operate responsibly, and shifts away from the company. I would not be relaxing up on that if it were me, because actually it's much easier to manage all of your other regulatory obligations if you're bringing everyone that works
And
with
the
you
thing
along
is,
with
like,
you.
if you're going to be an ethical company, an ethical user, you should be trying to do the right thing. And then the other thing I would
Yeah.
say on the whole training piece is don't hold off on the training, because we're seeing, and we did some research that came out quite recently, and we were seeing like
Mm.
this incredibly high shadow AI use amongst the Irish companies that we surveyed.
Huge. Yeah.
And you want to train the people so that they're not like leaking your data out onto a free version of ChatGPT. I get a pain
My
in my stomach when I think
goodness.
about that.
I have I had a client who said, I'm not sure we're going to do anything on AI because it's such high risk. And I was blinking in horror. So if you don't, then I'm afraid your risk's going to escalate, because all of this is quite a creative company. They were producing a lot of content. And I was like, if you think that you actually stop your junior staff from
Using
making
it.
use of all of these tools, if you don't provide them a safe kind of on-prem, closed-loop, secure
Yeah.
system for them to generate content, they are going to use a
Or they'll
range
leave
of
you.
available chatbots, or frankly,
Mm,
they will leave you and they will go elsewhere,
yeah.
because why would I work somewhere with a typewriter when everybody else is
Yeah,
working on iPads? That's the situation, really.
exactly. Speaking of the whole image thing and creative, another thing you were quite excited about when we met was you were talking about the Getty and Stability AI ruling.
Yes.
So you had mentioned feeling something stirring in the force. So do you
Yes,
want to
this is.
explain to everyone what does that actually mean, and what does it mean for both users of AI models in the UK and Ireland, and also trainers?
Yeah, I should say that, yes, it's possible that the things that capture my eye when I'm sitting around on holiday trying not to work, a sad indictment of the state of my life. But yes, I was away and I saw that the Getty judgment, a significant size, as many English law judgments are, was published, fortunately. And shout out to my wonderful colleague Zhu Yang Zhu, because she is, as well as being a brilliant sort of AI and IP lawyer, also quick off the mark, because she did lots of work producing excellent summaries that I immediately digested and thought, okay, this is a sort of judgment that's important because it happened, not because of what it said. We've been waiting for this for a long time. Effectively, Getty, the great image repository, had brought a claim against Stability AI over its stable diffusion kind of model and product.
Can I ask you, did they bring it against Stability AI? Because Stability AI were first off the tracks. And then you had Midjourney, and then you had the rest come follow. So it was because they were being taken to court because they were first.
I think it was partly because they were first, and partly, I suspect, because of the one aspect of the case on which there was a partial victory for Getty, which was the trademark bit. We think this is a copyright case, and it was very much about, are these images that are being spat out of our model, because they've been fed on Getty images, are they infringing copies? And a secondary question of, is the model itself an infringing article, which is a slightly challenging concept, which works under English law and probably work even less under Irish law. But the reason I think a lot of this came about was because a lot of the images that the stable diffusion model were producing had blurry, fake Getty watermarks, because they'd been fed with so many Getty images that it was one of those things that it spat out a watermark, thinking that was an inherent part of the image. And this was something that was actually dealt with quite quickly and addressed. It really only happened in early models, but I suspect it really drew attention to the use of Getty images as feeding this model, and probably contributed to the fact that they were the ones against whom the claim was brought. Other offenders in the eyes of Getty, although not in the eyes of the court, I'm sure were available. But it was quite interesting because that minor trademark point was the only element that ultimately succeeded. A number of other things were dropped and not pursued, and this question of whether could this be what's called a secondary infringement, could the model itself be an infringing article, the ultimate determination was no change here really. This probably isn't copyright infringement, at least not on the law as it stands. And I suppose that's the thing I would take away, is that it's proven that the legal system isn't really designed to consider copying in the context of, actually, we've been fed by 1,000 images and this isn't a direct copy. Copyright law protects really you've got to really copy the detail, not the concept, not the general notion. It can't be this picture is on a similar theme. It has to be this picture is almost indistinguishable from another, particularly in the context of photographic images or photographic style images. So the current position is, as long as you are not your model with just images from just one source and taking all sorts of risks that would encourage a court to look again at the situation in terms of actually the use of for image generation in the UK, and likely, I'd say, in Ireland and Europe, because of very similar, albeit far from identical systems, you can do so with a relative degree of confidence now that you're not going to be slapped with a copyright infringement suit. But it's also likely to prompt. It's also exactly the fact that this is said, okay, the law isn't really fit for purpose. This isn't going to protect original creators, image repositories. I suspect that we will now start to see suggestions about revision of copyright law and potential changes to factor in the rights of original creators, because at a certain point, AI starts just feeding itself, and we end up in a scenario where there's very little original creation going on. So it would be bad for us all.
That's a really good answer, Jo. One of the things that my mind was thinking about there was the law isn't really fit for purpose for this new world. I don't think anything is. If you think about say the markets and how they are reacting to the pricing of AI coming into our global economic system, I don't think economics and finance is also fit for purpose anymore. I don't think education, the way it's set up, is fit for purpose anymore. I don't think there's a lot of things fit for purpose anymore. We need to change everything everywhere always at once.
Agreed. I do think there is something to be said, though, for the fact that this is in fact the culmination of a period of time whereby things have been gradually becoming less and less fit for purpose. When I was doing my GCSEs, so junior cert equivalent in the UK, I was still doing everything from books. And then when I was at university, I was doing almost everything from books. Now, I have my degrees in history. I was a medievalist, so you might expect more books than but education has shifted, and the way in which people learn has shifted. And I think it's almost that we're not really fit for a digital world. And then you compound the particular IP and data and related challenges of AI, and it becomes more complicated and more difficult. I remember the dot-com bubble, right? It's not like we're not using websites anymore. It's just we don't overprice digital businesses to quite the same extent. And the same, I think, will be true of AI. There needs to be a little settling of the market and some calming down. But I will leave commentary on that to the economic experts and stick to my law.
We'll see what happens. Now, can I go completely around to the other side of the fence here? So we've been talking about EU AI Act. We've been talking about the Stability Getty case. Tell me a little bit about the Vagina Museum. Yes, folks, you heard that right. The Vagina Museum. Jo is a trustee at the Vagina
I
Museum.
am.
Tell me about that. That sounds so interesting.
Yes, no, I'm a very proud trustee. The Vagina Museum is the world's first and I think still only bricks and mortar museum dedicated to teaching people about gynaecological health. It's also a really fun space. I'm very proud to work there. It was something that some years ago, when I was a more junior lawyer, but on my way up, and I was thinking, I'd really like to start doing some charitable work, some trustee work, to start using these skills in a different context. And I mentioned this to a friend who spotted in The Guardian, I think they advertised for new trustees for this new museum, in particular trustees who had legal or other sort of specific expertise. And my friend had sent this to me with a sort of lol, here you are, here's a trustee role. And I looked at it and thought, yes, there is a trustee role here for me. So I got in touch and applied, and the rest is history there. And I'm really proud of the work we do. I've also just gone into the dark because so exciting is this conversation. The lights in this room have gone off. I've been sitting so still, wrapped to talk to you.
It's a lovely light now. It's not all yellowy. It's really nice. Yeah. whatever is working for you.
Yeah.
And what's their goal? Is it to educate the public as to?
It absolutely is. It's to provide all sorts. So we've done great exhibitions on endometriosis, on the menopause. We have a brilliant standing exhibition which looks at challenges around menstruation across the world and looks at some of the cultural and social challenges and historical issues that have and continue to keep women and girls out of education and out of the workforce. In many cases, very unwell. There are a terrifying number of unnecessary deaths every year as a result of untreated issues, many of which are avoidable because ultimately help has not been sought because of stigma or shame. So it's something that is incredibly important. And as well as the physical building, which we felt was important, that people have a physical space to come to and a community space, that we also do a lot of really interesting online work and collaborations and things. So it was a really interesting way for me as a lawyer to support and help out. And it means I do all sorts of things. So we have all sorts of interesting privacy and IP issues of our own, but also we have to have a lease, and so there are all sorts of things where I'm sort of flexing muscles that I have barely used since law school, which is healthy for me, and the sort of thing that hopefully, if the AI revolution goes the way I want it to, lots of people will have the chance to diversify and do more things because they'll be freed up and energetic. Exactly.
That's fantastic. And if anyone is listening and you're planning a trip to London anytime soon and you might want to drop in, it's in Camden, isn't it?
No, we moved. We're in Bethnal Green, and a very cool site in Bethnal Green, quite close to the V&A Museum of Childhood, very close to the tube station, under railway arches. It's a very cool space.
Very cool. And come here, one last question. This has been so interesting. And anyone who's listening who's saying, I'd really like to find somebody to help me with my data protection, cyber, IP law. As you can see, Jo is a very straight talking, very clear speaker. What would be one piece of advice that you would give to, say, a company who's just struggling to really do the right thing with their AI use? They don't want to strangle innovation. What should be their first step?
So my first piece of advice to everyone is, before you get overwhelmed with not just AI legislation, but all the new digital regulation and obligations in general, my one sentence is focus on the vibes. So think about, what is it you're doing? Who is it for? And what about what you are doing or planning to do might give them the ick, to use a very late millennial phrase.
You see what I say? This is like straight talking law.
And there's a real challenge, I think, within organisations that you talk among yourselves, and you can talk yourself into thinking almost anything is okay, or that almost anything is clear and straightforward. And why wouldn't people understand this if they just need to read our 10,000 word privacy notice, and then they'll be really clear on what we're doing. And I would say, no, don't ask the people that work around you if you can avoid it. Think about, who is this for? Who needs to understand what I'm doing? Who am I looking to serve? Who is going to be impacted by it? If you can find yourself half a dozen people, of varying ages and educational backgrounds, and talk to them about what it is you're doing, what makes them think, oh, don't love the sound of that, and what makes them say, oh, okay, yeah, no, I get it. And once you understand that picture, so much of kind of legal obligation on us is around transparency and clarity and understanding what's just, if it makes people go, oh, I'm not sure about that, then you know you've got some work to do, and that's where you focus. So before you worry about all the technical things about, have I got to fill this in? Do I need an external certification for that? What kind of notices? All of that stuff, you start from first principles. What is it that might make people raise eyebrows? And then ultimately, if you think, okay, I need some help, I need to go get some legal advice or get some consultancy support, you know what the questions that you're starting with are, and you know what it is that's ultimately, if something went really wrong, what would be the headline? What would be the tabloid headline that got you caught out? When you know what that is, you know where to start, even if you ultimately have to call in some troops later to support you.
So I'm thinking, think the ick, think the headline. If both of them are not looking good, you can contact Jo, who heads up a great team at Taylor
Always call
Wessing
me.
Dublin. I'll put your LinkedIn and your web address up onto the show notes. Jo, thank you so
Grad.
much for coming on. This has been really
Thank you.
refreshing. A fast talking, clear thinking roll through the latest in EU AI law. And this has been really great. Thank you so much for coming on the show.
Oh, thank you. It's my pleasure.
And thanks for everyone for listening. And just to say, if you liked the sound of this, do us a favour and give us a follow. We put out great shows like this every couple of weeks with lots of interesting people doing interesting things, bringing AI. So follow us and come back for the next episode of Chatting GPT.